Appeal in and for the 5th District of the State of Florida is now in session. The Honorable William E. Palmer, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. God save the United States of America and the State of Florida and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. As you've already heard, I'm Judge Palmer. To my right is Judge Orfinger. To my left is Judge Lawson. There are 4 cases on the docket today. There will be a panel change for the 4th case. So after the 3rd case, we'll take our morning break, and the lawyers are invited to join us for coffee if they like in the lawyers' lounge. We have both criminal and civil cases on the docket today. 15 minutes per side on the criminal case, 20 minutes per side on the civil case. First case on the docket is the State of Florida versus Figueroa.
Good morning. May it please the court, my name is Pam Kohler. I represent the state on this appeal. The state is appealing from an order granting a motion to suppress. The issue is whether or not the defendant was in custody for purposes of Miranda. In this case, basically, we have a defendant who was at home. The detective, plainclothes detective, showed up with a DCF officer and to ask some questions. They spoke. There's some kind of an inconsistency about exactly how they got into the house. Either it was the older daughter or the mother who let them in and directed them to the dining room. And they began to question the mother. And they asked to question the youngest victim. She became upset, so they went out to the driveway. She was allowed to run, she was getting so upset, so she wanted to get her mother, so she went back into the house, got her mom, brought her mom back out, and then she actually made a statement to the officer and the DCF officer. They went back inside. Whether or not the defendant was coming out of his bedroom or whether or not the mother actually went to go get him is also unclear by the record. But at some point he was asked to speak to them, and there's a tape recording of the entire interview, which this court does have. And he was basically told that they were there, that apparently there had been some kind of a verbal altercation between the defendant and his eldest daughter's boyfriend the night before, and some allegations came out again about sexual abuse. So the officer said, "That's what we're here about," and he said, "Well, the defendant's basically like, they said I raped her, I never raped her," and so then they started talking about the fact that he said that I guess the niece would present herself to the defendant, take off her pants, and then would ask to see the defendant.
Question of whether individuals in custody for Miranda purposes, we look at that de novo, correct?
Correct.
Okay.
Because that was a legal determination.
Totality of the circumstances determination, but there are 4 factors that court.
On the Ramirez, yes. The first is the manner that he was summoned. In this case, basically, they showed up at his house. He's let into the house. It's about 6:45 in the morning. The officers, they didn't come in with a warrant. They didn't come in and ask to search the place. They didn't come in and tell him, you need to stay in the bedrooms while we do this. The mother said that she felt free to move about the place. As far as the time, the manner and so forth of the questioning, the interview was very non-threatening. They never displayed their weapons, they never touched the defendant, and they never told him he wasn't free to leave. He never tried to leave, he never asked to leave, and then someone said, no, you can't leave, or touched him and said, sit back down, or anything like that. From all accounts, the floor plan of the home was very open. Apparently there's this great room, as the mother called it, and she said basically you walk in and it's the living room area, and then there's an open doorway into the dining room, or an open area into the dining room, and then there's the kitchen off, which is another open doorway. About a little bit into the interview with the defendant, another officer arrived, a street cop. She stood, she said, between the kitchen and the dining room, so she was actually, I guess, on the other side, so she wasn't, it's not like she was standing in front of the door, between the defendant and the door, or anything like that. And they didn't there was no closed doors. He was not in a tiny room, with the cop by himself. He wasn't restrained in any way. They were allowed to walk about the space however they wanted to. He was confronted with evidence of his guilt, and I think that's the biggest issue in this case, is that he was confronted with evidence of his guilt in this case. But even though that is not dispositive of whether or not a defendant is in custody for purposes of Miranda.
And the fourth factor, he was not told that he was free to leave, correct?
Which, yes, but I think that's more important personally when you're at a police station than when you're at home. I mean, a police station is just inherently coercive, so telling someone, look, you're free to leave any time is much more important, I would submit, than in your own home, when you can basically tell someone, get out of my house. But the most, you can tell, the judge found this was not coercive, that he was not threatened, that basically the state is allowed to use this as impeachment, for purposes. But, they basically just talked to him, and eventually he admitted that to some of the things. I would like to point out that even almost at the end of the interview, he felt free enough to correct the detective. The detective was like, well, you admitted that you kissed the girls, and he said, no, I never admitted that. And this was on page 105, the confessions between 82 and 111. So, even close to the end of this interview, he felt free to correct the officer and say, no, that's not what I said. I didn't say I kissed the girls. They kissed me. So I think that whether a reasonable person in his position would feel free with his custody, I don't think he was deprived of his freedom in a significant way for purposes of Miranda. And if this court has no questions, I'll reserve the remainder. Thank you.
Police Court. Morning, Judge Palmer, Your Honors. I'm Sean Wagner. I'm appearing on behalf of the appellee, Eduardo Figueroa. Judge Lawson, you asked of counsel for the appellant whether the standard review is de novo, and my response to that question, had you asked it to me, would have been kind of. And I say this is because the application of the facts of this case to the law will be reviewed by this court de novo, but there's another layer of the standard review in this case, and that's particularly the presumption that the trial judge's ruling was correct. Rulings on motions to suppress come clothed in appellate courts with the presumption of correctness, and it's the challenging party, in this case the state of Florida's burden, to prove that the ruling was clearly erroneous and therefore overcome the presumption. That is borne out in the case law cited by the state, the clearly erroneous standard. Several of the state's cases have cited that, so I'm not treading on new ground here. So I think the question would be properly framed: has the state overcome its burden of proving that the judges really has the state overcome the presumption of correctness in the judge's ruling? I would note that the state has not challenged the judge's factual findings, and since this is a mixed standard review and the judge's factual findings are only reviewed by abuse of discretion.
Well, the factual findings sort of helped the state. I don't know why they would challenge them. The factual findings were that they didn't intimidate him, they weren't coercive, that the manner in which they caught, all the factual findings would seem to help the state. Right.
I would respectfully disagree. The trial judge's factual findings were essentially that 6:30 in the morning or so, officers entered Mr. Figueroa, the appellee's home, without being invited. They were invited by... Right, but not by him. So he was actually holed up in his bedroom, kind of, and the testimony from his wife and the finding made by the court, I believe, was that he was sitting on his, you get this image of him sitting on the counter in between these two double sinks, kind of with his head down, this forlorn expression. He was nervous, his hands were shaking when he walked out of the bedroom. He was actually summoned to come out of the bedroom by the police, and you look at DCF investigator Grayson said that we asked Mrs. Figueroa to go get him, so she came in and by her own testimony said they need to speak with you, they want to speak with you, and so he came out nervous, forlorn, obviously concerned and upset, sat down. The stark difference here, and this is another finding that the trial court made, was that Officer Smith, the uniformed patrol officer who was there by...
But the finding was, quote, it was unclear from the testimony whether the defendant's wife summoned the defendant into the dining room or whether the defendant himself came into the dining room. And then he also found that the officers did not coerce, threaten, raise their voices, or intimidate the defendant.
Well, yeah, the trial court's finding is that it was unclear. If you look at the actual testimony, that there was disputed testimony, as Detective Coulter said that he doesn't remember whether he summoned the detective, and DCF investigator Grayson says that he did. So the judge's finding essentially was that it's unclear what happened. One way or another, he was summoned out of the bedroom. He didn't come out voluntarily. I think that's an inference that the court made, and that's the inference that the court considered. Now, if you think about the situation, it was said in the briefs, and it was said here today, that interrogations typically happen, custodial interrogations typically happen in police stations, and they don't happen in the home. I would argue in this case that this venue was more intimidating than a police station, and here's why. It's 6:30 in the morning. The police are essentially, from the appellee's perspective, essentially invading his home. He didn't let him in. It's not like they came in illegally, and we're not saying it was just kind of a warrantless search, but he didn't let them in. He was never really able to come out of his room until he was summoned to come out. And he's met when he comes out at his dining room table with a DCF investigator, with an armed police officer, and shortly after, within minutes after his questioning started, Officer Rebecca Smith showed up, uniform, gun, badge, everything else, and she stood within feet of him, essentially guarding him the entire time he was being questioned. And the court obviously found Officer Smith's presence at the interrogation to be incredibly significant. And I would note for the court, actually a case that the state cited, and that was, I think it was Killian, where the defendant was actually told to stand by a tree, and then he was watched the entire time. Now, that case was a tiny bit different because the officers came into his...
It doesn't make common sense to me. You seem to be arguing that the first two factors would favor a finding of the defendant being in custody, but I can't imagine, I've never seen a case that would suggest that police coming to someone's home, knocking on the door, and asking if they could talk with them about some allegations has been determined to be coercive. I mean, that's the kind of setting where courts have uniformly, to my knowledge, found that those first two factors would favor a finding that the defendant was not in custody. Police come to the home, knock on the door, and say, "Can we speak to you?" I don't know what about that would indicate custody to any reasonable person.
Well, Your Honor, we actually hashed that out in arguments at the trial level. And all of the cases that stand for, and this was exhaustive, and I looked at the state's case too, and I stand by this position. All of the cases that hold the general proposition that you're typically not in custody when you're questioned in your own home have a factual presupposition that the person being interrogated invited the officers in. And if you think about that, can we speak with you? Sure, come on in. You're voluntarily inviting someone into your home versus them coming in, invited in by a family member, questioning your entire family outside of your presence, and then summoning you from your bedroom.
Well, there wasn't a finding that he was summoned, right?
It wasn't a finding that he was summoned. There was a finding that it was ambiguous as to whether he was summoned.
So your argument really can't be based on, we should find this because he was summoned, right? We can't make that factual determination. The trial court didn't make that factual determination.
I wouldn't say the trial court made this distinct factual determination of summoned. I'd say the trial court made the inference, but the trial court was not willing to resolve the disputed testimony between DCF investigator Grayson and Officer Colton.
You can't resolve disputed testimony between those two witnesses.
No, but you can take the court's, in fact, you're bound to take the court's reasonable inferences. And I think the court made an inference that there was some coercion in the way he was whisked out of his room, however you want to describe that. It was clearly an inference.
Factors, I mean, it seems that we have taken a best-case scenario from your perspective. We have the police summoning him out. And it doesn't seem, from what I've read in the testimony, it's not like they're shouting, come out with your hands up or else. They may have sent the wife in, or they may have, maybe they yelled and said, "Hey, come on out," or something. So arguably that might help you a bit, and you've got the uniformed officer standing by. Those are historical facts that, if we indulge ourselves and say that there was a summoning to help you as much as possible, Is it correct then, though, that we take the other facts that don't apparently, that aren't in great dispute here, and we make our own determination, the de novo review, as to whether or not a reasonable person, not him, but the reasonable person would believe that they were not free to leave and that they were in custody?
That is correct, with the caveat that that there's a presumption that the judge's findings were correct and that all of the judge's inferences as well as factual findings were
Well, that's
correct.
true only as
Right.
it relates to the historical facts. I mean, it kind of
Correct.
negates the idea of a de novo if that's the case. So do we then have to take a look? I mean, am I correct that we look at the Ramirez factors, and if we're looking at them in a light most favorable to you, we say, okay, well, maybe he was summoned out. And I don't think anybody's contending that they're out there with bullhorns and screaming,
That's correct.
come out with your hands up and all that. You know, it's, come on out. And we've got this other officer standing there. And is it correct then that those things, we make a de novo determination as to whether the reasonable person would feel that the atmosphere was so coercive that the statements made have to be suppressed? I mean, is that the test that you think that we have to apply?
I would agree with you 90%. The other 10% is that you also have to consider the totality of the circumstances.
And 90% is better than I ever get from my wife, so I'm good with that.
So if I could indulge the court and talk about the totality of, well, two factors I haven't discussed yet, and then talk about the totality of circumstances. First of all, Judge Lawson, I believe you're correct. The first two factors are not the strongest in favor of our argument. I've spent now 2/3 of my time talking about them. The most important factor and the most troubling factor for the trial court was the manner in which the appellee was confronted with the evidence of his guilt. If you recall the transcript, and I've recited it in my brief, Detective Coulter was a school resource officer before he was a sex crimes and persons crimes detective in the role investigating this case. And he had actually investigated prior instances of sexual abuse with one of the same accusers, the older of the two daughters, and as a school resource officer, and he said, you know, in plain language, look, Eduardo, the first time your daughter made this allegation, I got to say I didn't believe it, but now we got another one of your daughters coming forward and saying the same thing, and I'll tell you what, now I believe them. And I'm a human lie detector. He called himself a human lie detector when it comes to children, and I know when children are lying to me, these children aren't lying to you. The reasonable person, not you know, any subjective standard, when confronted with an armed detective who says, I've got history with these kids, at least one of these kids, I've got history with this case, and I think you've been sexually abusing two of your daughters, does not think he's going back to his bedroom to get dressed. He thinks he's going to jail in handcuffs. A reasonable person would not believe an officer who's got the power to arrest you, who says, I believe you've committed multiple serious, morally and criminally serious felonies, is going to go home and is not going to jail. That's, I think, the most troubling factor.
Was he arrested on the spot?
He was arrested after the confession. Formally arrested, well, I said that gingerly, formally arrested, and he was put in handcuffs and transported to the station in the county jail. The additional factor, taking the totality of circumstances, the coercive nature of the situation, was that Officer Rebecca Smith came by the court's finding and by the officer's own admission, as security, as backup. Now, you don't call in a plainclothes officer for a casual, consensual interview for security. Why do you need security for a casual, consensual interview?
There's some testimony she was there because of the possibility of a child pickup?
There was some testimony of that, but but I think we're talking about the reasonable person, not what's going on in Officer Detective Coulter's mind. And the reasonable person thinks, I'm being confronted with these allegations of sexual abuse, very serious sexual abuse. This detective is telling me, he not only does he think I did it, but he's a human lie detector, and he knows I did it, apparently. And now this armed officer shows up, standing there. And by the way, she was standing within several feet of him the whole time. And I would also note another thing, is she wasn't there for the interviews of any of the other children or the mother. So there was something different about his interview, where now the road patrol deputies are showing up. That's highly indicative of the fact that you're going to jail. They're coming in, they're guarding you, they're questioning you, they're confronting you with evidence of your guilt, and you're going to jail. The other significant factor to isolate them Judge Lawson, before I run out of time, is that he wasn't told he was free to leave. I disagree with the proposition that that is more important as a general proposition when you're in a police station. I think every case is evaluated on its own facts, and if he were told, look, casual conversation, we're using first names here, look, Eduardo, we just want to talk to you. You don't have to talk to us. You're free to leave if you want. You can get up and leave. I think we might be having a different discussion, but he was never told he was free to leave. And the fact that he was never challenged in his movement, I think, is somewhat insignificant, because if you watch the video, or at least read the transcript of the video, he didn't try to leave. And quite frankly, that might have had something to do with the fact that he had Officer Rebecca Smith standing within feet, literally arm's length of him, so she could have reached out and grabbed him at any time. I think the fact that he didn't personally invite these officers in negates a lot of the case law about this idea that you're not in custody when you're speaking to police in your own home. The way he was confronted with his guilt and the fact that he wasn't told he was free to leave are the most important factors. Taken in the totality of the circumstances, step back from it a little bit. The other thing that Ms. Kohler had kind of touched upon, and it's certainly in the record, is that there was a previous, this started from a criminal investigation that occurred the night before, where Mr. Figueroa Peli had actually been accused of committing a violent crime against one of the daughter's boyfriends. The daughter's boyfriend then accused him of engaging in sexual abuse of the daughter, and then the police showed up. So for all he knew, he could have been being investigated for a violent crime as well as a sexual crime, and that's important to consider. Thank you.
Thank you, counsel.
As far as the defendant just hovering in the bedroom, I mean, it's clear that whoever went to go in to get to the police officers, I mean, they were both told, both of the parents, let me go back. The officer asked to speak to both of the parents when they first showed up. So the defendant, if he had wanted to come out and say, get out of my house, I know what you're here for, get out of here, I don't want to talk, he could have. He didn't have to sit hovering in his bedroom or whatever, or the bathroom, whatever he was doing. There was no point that the officers ever said, stay in your bedroom or else. They never told anybody. Apparently the kids were all staying in the bedroom because the eldest daughter just kept them there. And like I said, the wife testified she felt free to move about the house. As far as the interview itself, I mean, it's not like the defendant broke down as soon as the cop said, I'm a human lie detector when it comes to kids. He didn't break down when he said, I'm going to just appeal to you as a father. It wasn't basically until he started talking about, well, I admit that you never forced them, and I know that you never penetrated their vaginas. And then the defendant was willing to talk more about what actually occurred. So it was more getting to where the defendant wanted to be, that he wasn't going to admit to, that there was any force used and there was no penetration. And the interview only took 20 minutes, and once again, I thought this was not a coercive interview. The defendant's in his home, and yes, he was confronted with evidence of his guilt, but there was never any indication. He was never told, we're staying here until we get to the bottom of this, you're not going to be able to leave, like in Killian, he's basically told, you need to stick around until we're done, things like that. None of that was ever done in this case. So I would ask this court to reverse the trial court and allow us to use this confession at trial. Thank you.
Thank you, counsel.